Well, thank you. Welcome, Arnold. So good to have you on the Talk Out Talk Show podcast today. I appreciate the time you're taking out to give us your wisdom, your stories on all things Papua New Guinea. So, yeah, appreciate the time. Let's get started with some biography, and I really love to hear some of those stories that maybe we don't know about that are not in the public space. But tell us a bit about your upbringing, where you were born. Tell us a bit about your parents, your siblings. What was their childhood like?
Yeah, I'm a Cultural Islander from Madang, born on the island, and then grew up in Ley. Went to school there. My father was a medical assistant, health extension officer, working on Karkar when I was born, and then got transferred to Ley at the old Malahang Hospital in Ley that Moravians will know that no longer exists. And I grew up there, and then started school there at where the Kasawari Road Uniting Churches is a school there, and then second grade or first grade in Chinatown, and then second grade at Butiban Primary with Utula Samana. Many decades later, we caught up at university. And, amazingly, we kind of knew each other and related to when we started school. And then from there, father transferred back to Madang General Hospital. And so I grew up there at Modilon and completed my primary school at Cusbao. And then attended a continuation grade 6 boarding school in the north coast of Madang called Talidik, where the year before, so I went there in 1964 to do grade 6 boarding. And Grand Chief Sir Michael was a teacher in Madang in those several years and taught there in 1963. He left to come back to Port Moresby in 64 when I went to school there, and his name was all over the place during those early days, having taught at Tusbab High and then to Taladig. I then came to Tusbab High, did the first year there, and was fortunate to be awarded a Australian Education Scholarship pre-independence with a bunch of other Papua New Guineans during that period of time, and completed my secondary education in Australia, northern New South Wales, in an education town called Armidale, with a whole group of guys, some of whom are senior Papua New Guineans now, that whose names people would recognize: Sir Robert Igara, former Chief Secretary to Sir McCary, and now the Chancellor of UPNG, former Governor of the Central Bank, the late deceased Sir Wilson Cummett, and Robert Icey, who's now with the Chamber of Commerce. So, and then a judge who presently on the bench, Sir Kinabona. So those were the Armidalians, and so that's where I finished my secondary education, and then came back to UPNG in 1971.
So what was it like, and what are some of the things that happened perhaps in those primary school or high school days that kind of shaped you in terms of the trajectory of your life?
Well, I guess later in deciding what kind of career I would pursue was really having grown up around hospitals and doctors and nurses. I thought I should become a doctor, following after my old man. But that wasn't to be. My sciences were poor. So I actually applied to do foundational science for medicine at UPNG in 1971 when I came. But starting foundation year science just showed me immediately that it wasn't cut out to be a surgeon. So I switched to law. So I guess growing up in those several places prior to doing secondary education just enabled me the education background, I guess, in an urban atmosphere, and then the privilege, and I guess because of being brought up by my father to being reasonably better at in my grades, so selected to do the test for the scholarship, and so that began my education career.
What about your mother? What is she like?
Mother was a villager, but of course brought me up faithfully in the church in those early days in Madang. Then, of course, my church journey continued when I attended an Anglican boarding school, boys' Anglican boarding school in Australia with Robert and a group of others, and that kind of reinforced my youth Lutheran background. Where at the Tusbab in the first year we got confirmed. Our headmaster, an Australian, was a Lutheran, so we'd attended the Memorial Church in Madang town. So that kind of grounded me in my faith journey. Having gone to then a Anglican church boarding school, chapel every day, twice on Sundays, the basic doctrinal foundations of our Christian faith was truly strengthening my very core values.
And siblings?
Only one.
Only one
A
sibling.
younger brother, Stephen. He unfortunately is deceased, and I'm the only surviving Amet.
Did he pass away earlier on in life?
No, he was reasonably educated as well.
Okay.
Did civil aviation and was working with civil aviation when he died.
Okay.
He grew up in Papua. My father then transferred from Madang to Rabaul before I went to Australia, and then came to work in Cape Rodney in a health center in Bomguina, where my brother went to school, and then attended Quikila High School, and then went to Ayura. So that's my growing up. So from school, I'd come and go to spend holidays in Cape Rodney, where I knew of Sir John guys, and in the villages where Pukatemu comes from, in that area of our Papuan Abau area.
Yeah. What would you say is some of the things or most memorable things that your father would have taught you growing up, or you observed, and that it left a lasting impact on you?
Yeah, my father was a disciplinarian. Growing up in Madang, I and my younger brother would spend a lot of time playing marbles. I became a real marble champion. And so one day we'd come home late for dinner. And so one day he said to my brother and I, the box we had built to store all of marble exploits, take it down to the beach and throw it out over the sea. And then when he punished us, he'd have us carry a log to stand outside the house for a period of time. So that's what I recall about my dad. He was a strict disciplinarian. And I guess it kind of rubbed off on me a little bit with my family.
You also were a strict parent, would you say, or father to your children?
Yes. And then, of course, going to the school that I did, very disciplined, boys-only church boarding school, getting up early in the morning, around the block, physical education, into the shower, to make your bed, stand before the bed, and then going to chapel every morning, queuing up in your houses. The prefects would inspect your shoes to make sure you polish them. So it kind of instilled a sense of discipline that has held me in good stead in my whole life.
Yeah. From Armidale, you came back to UPNG. I had a question about how that happened, and was there an opportunity for you to remain in Australia and continue university education after secondary school, or was that the end of the scholarship and then you had to come back?
It was the end of the scholarship, and we applied back to UPNG institutions, PNG institutions. UPNG was one. I know that others were given opportunities to study in other Australian universities, like Benanakobi, Anthony Seguru, Sugurikiru, all went to Queensland University and other places. So I guess that was available, but where we went to school, we all came back to UPNG.
Right. So let's move into, so that I wanted to touch on the teenage years and maybe the early 20s in your youth, especially. and it coincides with the coming of age or the almost the birth of Papua New Guinea. What were those years like in terms of the conversations, but role models especially?
Yes.
Who were your role models growing up as young people at that time?
Well, I should tell you, the word comes to mind is it was exciting.
Yes.
You really need to have lived that to know. And I had the privilege of addressing the orientation of the first year intake to UPNG early this year in January, invited by the University Council. And the first is that I spoke to, that's going back 54 years when we
Wow.
came to UPNG in 1971. And it was absolutely exciting. The country was excited with the potential of the independence journey, self-government, first part in 72.
Mhm.
Grand Chief became Chief Minister. In 73, we took full self-government. And then 2 years to 75. So all of those years were exciting. I think academic study was secondary to serious national politics. It all centered around UPNG Forum. And so growing up in those early years, our seniors who became the founding fathers were all present. The Grand Chief, Sir Julius, Teabal, Paul Lapun, Bernard Narakobi, John Mommers, John Caputin, and our senior academics come public servants, the Gang of Four, Mikere Morota, Ravi Namaliu, Tony Seguru, Bart Philemon, Sir Charles studied offshore. But those pioneer leaders, both political founding fathers and our senior executives that I later rubbed shoulders with, played rugby with,
Yes.
and they were truly inspirational. And I had the privilege of one of a handful of walking with them, being their junior during those years, to then joining them on the table in my career.
And it was a very obviously PNG was very young or about to be born, and there was not many, I suppose, public figures or national leaders at that time that the country could look up to. So these were the guys who they were like trailblazers, I suppose.
Oh, absolutely. They were the ones.
Yeah.
All the political leaders regularly, weekly, monthly, on the UPNG campus. That forum was the center of where PNG politics was debated. Because there was the Bully Beef Club at Wangani Admin College and all of that that's been written about. But the open air public discourse was at UPNG. And we all got caught up in it.
Yeah.
And the debates that were going on, we would debate the Constitutional Planning Committee report from 73, 74, and ultimately in 75. And so, those were just exciting times of our birth as a nation.
What were some of the key things that were thrown around or discussed in those forums and those issues when they were coming up? What were some of the things that you were looking forward to as a nation, that we were looking forward to by that generation of leaders?
Yeah, I guess the election process, a little bit vague, but some of the key issues in the Constitutional Planning Committee's report and the discussion for the adoption of the Constitution. And of course, by that time, 74, 75, I was a senior law student. So the issues of the governmental system, but more particularly the head of state. We had a serious debate on some of those, and that one in particular, in 75, I was the SRC president, and so facilitated a whole lot of those critical debates and discussions at the forum. And this particular issue, we debated vigorously in the final stages of the adoption of the Constitution by the Constituent Assembly. And we resolved overwhelmingly at the UPNG campus, the student body and the academic body of nationals, overwhelmingly not to adopt the British monarchy as our head of state.
Right.
And we marched on Waigani. I led it to the current government, central government offices, and presented a petition to the chief minister, Grand Chief Sir Michael. And of course, in their wisdom, they adopted it to this day.
Yeah, so that's interesting because that's what Dr. John Mommies mentioned in my last interview with him, that
Yes.
the monarchy was, for him personally, but as it was a general sentiment of the CPC, that would not be, we would not adopt the monarchy, the English monarchy as our head of state. And then, but what would you say was the thinking behind eventually kind of rejecting CPC's sentiment regarding?
I can understand, and then putting myself into the position of our founding fathers, a good number of them were minimally educated, teachers, medical professionals. Ruben Tareka was a doctor. Sir Julius was a businessman, reasonably educated, but a good majority weren't. And so at the inception of our independence, I think a hesitation to maintain some connection with the colonial administrations, Australia, and then the British monarchy. Australia still maintains that up to today.
Yeah.
So I think that might have been the reason why they went against the CPC report. And
would it be fair to say or describe it as the government trying to maintain sort of like that link, like an umbilical cord, so to speak, to the mother of the, not really releasing that connection? Would it be fair to say that's what's happened?
I think partially, but more I think about developmental support and needs.
Yes.
We are still part of the Commonwealth of Nations, though you can still be a republic and be a member, like Fiji and Vanuatu, Samoa, Tonga is a monarchy itself. So that at the time was not sufficiently understood.
Right.
There's been a review recently of the system of government by the CLRC, the Constitutional Law Reform Commission, instructed by government. And I've read a report that still our people still maintain that kind of a misconception that if we sever that tie with the British monarchy, we might not benefit from aid, assistance, and so on.
Right.
That might well have been a reasonable thinking at the time, but not so now.
Yeah. How about you personally, in terms of your political views, your political ideologies, or national ideologies? How was it shaped in those years coming up to independence, in your high school and then university years?
Oh, I was a passionate nationalist. I had the privilege of studying overseas, high school, and fully pledged Papua New Guinean at university. And so following in the footsteps of our founding fathers, that passion, and then our senior executive leaders, the Gang of Four, and a whole bunch of them over a generation, my seniors. And so we just rubbed shoulders and we became absolutely passionate nationalists, supported nationalism. That is why I supported and I led the march. Decades later, I sat on the table with Grand Chief as Prime Minister and as his Attorney General and Member of Parliament. And I'd say to him, Chief, you and I have unfinished business. We need to sever this umbilical cord.
Yeah, that umbilical cord.
But that's part of that journey. So yes, it was truly an exciting journey.
Yeah. You mentioned, I was going to ask, but you mentioned already about the level of excitement. How widespread was that level of excitement within the youths at that time, leading up to independence? Was it like I know probably at the university, there's definitely that excitement there. And these academics, people who are coming into understanding of how the world works. But how about nationwide? Was there an excitement plus some nervousness maybe in the people, maybe an apprehension of how are we going to do this as a nation?
Yeah, I think so. There was. I was as part of the student union. We initiated the National Union of Students. So we traveled to Goroka, to Unitec, to coordinate the youth, the young people, the student body toward this journey. and just for the future. And as we traveled, there was excitement everywhere. And I think there was understandable apprehension about what independence would mean. The
Yes.
educated elite and we young student body, we'd understand it
Yes.
because we could see the necessity for our own self-determination and so on. But our senior people, not as educated as we are now, obviously, and that was that opposition faction
Yes.
led by Sir Tayaba.
Yes.
So that was there, but by and large at the forum, you would hear overwhelming support. There was such excitement about what it meant to become self-determination.
Well, why was there that level of excitement? Plus, it seems like there was a confidence that we can do this. Why do you think there was that level of confidence, at least among the general educated population? But even if people were less educated, they still had that excitement. Why do you think there was that level of confidence?
I think at an institution like the university, you had a core of academic leaders and educated people at the highest level. And obviously, if we couldn't have that confidence, then we couldn't expect the rest of our nation's peoples to. And we rose to the occasion.
Yes.
As I remember mentioning those seniors of us, a whole batch of them that was senior. The first university graduation was in 1971. So there were a whole group of them that were seniors to us, Ravi Namalu, Sir McCarry, who had completed the university and had graduated or about to graduate in 1971. So they and the seniors at that time, 1971, 1972, 1973, I had just started. And so it's a whole batch of a generation of senior Papua New Guineans already in academia and as well as having in the final years, they've been graduates already. So we felt there was sufficient educated intellectual core to support our political leaders to obtain self-government and independence.
So this, notwithstanding that, there was, like you said, say Tayabal and maybe others like him who come from the school of thought that we were not prepped well as a nation, that maybe Australia did not prep us for nationhood. And there's still some of that thoughts today that we could have done better. I mean, it's all in hindsight now. We can't really go back and change the past, but are there some merits in that? And what, in your observation, did Australia do to prep us, to practically prep Papua New Guineans to take on nationhood? And maybe what could have been done better about that prep work?
In hindsight, also, I don't think that we could have done it any differently.
Right.
My group were about a second or third generation group of privileged few who were selected to study offshore. Your Narakobes and your Siagurus and your Kidus. There's your Lepanis. There's a whole batch of them who had studied offshore and were doing university offshore, and some had graduated. So there was enough core. And around our universities, there were senior men already graduating in senior positions, going to do postgraduate, like Sir McCarry, Rabi, who later became academic leaders and then into the leadership of the public service. So in my view, in hindsight, the Australian government did the best it could at the time, and I think time was right. I couldn't see any delay in it would have made any more difference than when our leaders elected we should obtain self-government.
Yeah. And there was this wave of decolonization happening all over the world as well. So we were pretty much on that wave as well.
Yes.
Happening. The PNG Constitution, and this I'm trying to zoom back out to present day and just get your thoughts on your perspective going back 5 decades now, pretty much, of nationhood. The PNG Constitution, when it was crafted and the national goals and directive principles were written into the preamble, the 5th national goal is the PNG way, that we would use Papua New Guinean forms of social, political, and economic organization With the recent amendments, now we have the word Christian forms of organization. So my question is, in your observation over the last 5 decades, and you've seen the nation through different lenses, you've seen it through all three arms of government, and now as perhaps a senior statesman, but a civilian, but obviously going to be serving now as the ambassador. But what is, in your observation, what is the PNG way? Have we crafted a unique Papua New Guinean way of development in terms of our social, economic, and political organization?
No. I think the principal advocate of that were John Momus, the decentralization model, and Bernard Narkobi, Tony Siaguru. I think all of the Gang of Four were serious nationalists, and I'm one of them. That we could have adopted the Westminster model, but in our implementation and the mechanics of doing governance, adopting some more of a Melanesian ways of reconciliation and governance involving, as was proposed by John Momus and John Capotin and advisors, some of our traditional chieftaincy model into how governance was practiced at the local level, even the provincial government level. Right now, as we speak, the New Islanders have adopted some of that model, brought in the Mamais into the assembly, and so the debate goes on. I think that vision has not truly got translated into reality. Though we have adopted and embraced the Christian principles that are far more in sync with our traditional lifestyles, in my view. The reconciliation, dialogue, the communal lifestyle that our Christian ethos commends, not in the worldly public commerce and industry and governance.
What would it look like if we haven't attained that PNG way yet? What would that look like in terms of practice and operation of government, social dynamics, cultural dynamics? What would a PNG way, if we crafted it well, what would it look like?
Well, I think firstly, our Christian principles and values that we all grew up with. Everyone grows up with mostly these days, unless you've grown up in the urban towns where parents did not really participate in church life as we did and our communal traditional societies are still very much influenced by that. Many may not go to church aside.
Yeah.
So bringing that into our public space in commerce and industry and in government management of our resources for the benefit of our people. I feel we can do better in how to ensure that our people, the traditional landowners on whose land resources are discovered and developed, can be better enabled to participate in the resources.
Yes.
And the lifestyles improved significantly and markedly more than up to the present time. I think we've lost the formula in that, in my opinion.
Yes. I agree. I think, there might be some aspects of the PNG culture that maybe are in their application have maybe had negative connotations, like the so-called one talk system, where in government it's kind of applied negatively in terms of that we have now it's elevated into a cronyism, rather than just one talk. It's like friends and or you scratch my back, I scratch yours kind of relationship, transactional policy. Even at the legislative level, it seems like there's an accommodating of that transactional leadership. Um, what are some other kind of PNG cultural practices that might have been applied negatively that have affected our development and progress?
Well, I think that's one, and it was never intended. And when you think of it, not ever intended for that to be brought into and applied and worked and used as an excuse for corruption and greed. In a communal level, that is an excellent model. We care for each other. We share our benefits together. What we achieve and accomplish. It wasn't intended to be formalized into the formal sector, but it is a Melanesian culture that holds us in good stead in peace reconciliation. When I sat on the bench, I would say to lawyers, have you discussed this dispute with each other?
Yeah.
And I'd say to the churches in particular, being a Christian, I'd say to them, don't ever come to court. We churches don't litigate in court. We should have the spirit of reconciliation. Now that is embraced and part of our traditional Melanesian culture of reconciliation.
Yes.
Peace negotiation. We make peace, then we pay compensation to one another. And before courts ever became formal in this country, that's how we resolve our disputes. Now, of course, they take them to the other extreme of eye for an eye and payback is not what we truly condone, but that happened in life. But by and large, the Christian ethos enable us to enlarge and amplify our traditional peace-loving way of relationships.
And there's also another, maybe as a pushback or another perspective that, we have our reconciliation methods, but then sometimes it's utilized at the cost of justice. Like, for example, when there's domestic violence and it's the worst case domestic violence where there's an actual killing of a spouse, the living spouse or the accused tries to settle that outside of the court system, outside of the criminal justice system. And then that's a kind of like a conflict or a tension between our cultural practice and this legal system that we've adopted. How do you suppose we navigate these questions when they come up from time to time?
I think it is reconcilable. I'm a strong believer, as was Bernard Narokobio, embracing our traditional methods of peace and reconciliation, embracing the customary methods of compensation, reconciliation, together with the model. And Bernard commended it, and I practiced it. I was a criminal defense lawyer in my brief career before I came to the bench, and I brought that on as a part of my jurisprudential thinking and philosophy, and I combine compensation with a minimal penalty altogether, with compensation orders, and the Supreme Court rebuffed me in one particular occasion, but I think it's still negotiable. That is that because the compensation reconciliation process is not individualistic. It is meant to be societal and communal.
Yes, communal.
Because an offense is offense against the clan and the tribe and the family. So if the offending parties do that, as well as then accepting and bringing into play in the judicial formal process the sanction under the law that is mitigated by that process, you can accomplish justice in the total sense, in my view, so that everybody feels as a measure of some justice having been effected, and ultimately the perpetrator might be sentenced to prison. But if you avoid that and don't embrace that, then there is still the tension that continues in society.
Yeah.
The offender might go to prison, but you haven't truly brought peace to the community.
Yeah. So there's the principle of restitution
Yes.
and restoration comes into play. I think what you just shared, I think, triggers for me like a simple, quote unquote, simple solution, in that the compensation and the reconciliation aspect of the offense, that can be a factor in like a mitigating factor in sentencing, rather than a substitute for the criminal process. Because what I have a problem with when I see these kinds of stories is the police taking a step back and say, okay, you plus threatin pinis law outside, so larim you also malusim also. That's not supposed to be the case. The police is supposed to continue or proceed with the wheels of justice, the investigation, the prosecution, and so on.
Different levels, I guess. If there's serious violence, if there's death, but if it's just a small altercation, and it's criminal, but it can be sufficiently reconciled.
Yes.
And a family harmony is restored, then that can be a discretion administered at different levels, even at the highest level. When I presided over matters where I felt that a dispute that could be reconciled harmoniously without the need to go through the formalities. So it's a matter of embracing it all and exercising wisdom and judgment in each particular case, so that you embrace the good of our traditional communal conciliatory restorative justice system, as well as the introduced.
Yes, I think that's a good kind of microscopic example of how we can merge our culture with the existing legal systems that we've adopted. If I could just segue into your legal career, tell us about your early practicing years after you came out of university. What was that like? Tell us about that journey that you started on as a legal career.
It was brief, actually. I graduated at the beginning of 1976, having completed the law in 1975, and then attended Legal Training Institute for 6 months to November, thereabouts. Got admitted worked at the Office of the Public Solicitor to do my 6 months for full admission.
Okay.
I was initially employed by the PNG Teachers Association as an industrial advocate while I was doing my legal training. But after I joined the Public Solicitor's Office, I decided I should stay there, resigned, and continued as a criminal defense lawyer from 76, 77 through to 81 when I became public solicitor. So my practice experience was principally in criminal defense. Traveled the country with the national court circuits. Those brief 6 years, 76, 77 to 81, I became public solicitor, and then 2.5 years later, in 83, I became a judge. And so my practice at the bar was very minimal. And I think involved in just criminal defense law and some constitutional cases in the Supreme Court.
I noticed that you would have become public solicitor, and before that, Samari as well became public solicitor.
He was the first national.
He was the first national public solicitor, and you were all really young legal officers or lawyers, and then became public heads of a government office. And I noticed in our early days, the government was run by very young. Of course, the founders as well were in their late 20s, early 30s, I understand. And so the government of the day was quite young. What would you think was the reason for that? I mean, obviously, I think because we're a young nation, obviously the crop of leaders who were qualified to take those positions were young. But what do you see was the general culture of the professionals at that time regarding their work ethic, the drive to excellence, drive to serve? How was it like in those early days?
I think we were also mentored, tutored, led by good um, seniors, Papua New Guineans like Somari, Jaburi Kidu in law, and some good Australian and English professionals in the public service, in all the public service, such that we, the young crop, were able to progress very, very quickly, learning the skills, uh, adopting the disciplines necessary to get promoted
Yes.
young in our careers. So McCary became Secretary of Finance at 27. I think the record would show. Somari went to the National Supreme Court at 29. I went there at 31. So Buri about the same age. So um, yes, we did progress very quickly. But in retrospect, we learned the disciplines very, very quickly.
Yeah.
And we were able to perform.
And what would you say, transitioning into the bench, what would you say was your motivation or inspiration to serve at the bench?
I think being a advocate in the traditional sense of barrister, courtroom lawyer, simply prepares you for that. There are solicitors who do office work and advisory and so on. I was an advocate. My gift was a courtroom lawyer, and I was sharp. You cut it out, and you were then recognized by the judges before whom you appeared, and they would recommend who is fit to be then invited to become a judge.
Right.
Appeared before the expatriate bench and chief justice at the time before Sudbury became CJ. And so when the invitation came, you knew you were prepared progressively in that career as an advocate in court.
Did you look ahead and maybe get some advice or mentoring from judges at that time who maybe recommended? Because what I understand about being on the bench is that, because of the nature of the job, it's a bit of a restricted profession. You don't have as much freedom as people not on the bench. But what about the position, those other aspects of the
Yes.
job?
Well, you kind of rub shoulders with the judges. You travel as a criminal defense lawyer. We did circuits throughout the whole country,
Yes.
from town to town to small towns like Mendi and Wabeg and Kerema and Daru. And you socialize with the judges at dinner. It was ethically appropriate. And you got to know the judges and they got to know you. And so I imagine that they would commend your promotion.
Right.
And you appeared before the most senior ones. And you'd get feedback that commend you. And so you were kind of prepared. And as well as your seniors and your peers, your senior lawyers with whom you interacted and appeared at the time, those senior expatriates in public prosecution and the public solicitors, who then all went on to become judges. So it was a culture in which there was mentoring and guidance. So you got the right kind of counsel and advice when you appeared. And if you were competent, the judges would commend you and they would interact with you. You had the interactive ability and you knew that you were being groomed and ready for the next stages in your career.
One of the things that I've noticed is in our day now is maybe there seems to be, I might be wrong, but I'm observing in the legal fraternity a general reluctance maybe to join the bench. I spoke to one senior lawyer. I said, "Are you interested in joining the bench?" Very senior, decades before me. But it didn't seem like he was keen to join the bench. And I look at the legal profession now and I see a lot of good senior lawyers that I think, in my lay observation or outside observation, I think they might be good for the bench, but there seems to be a reluctance there. Do you think that's a accurate observation regarding our legal fraternity?
Possibly. During my tenure as CJ, the number of senior lawyers that I approached and invited to consider being appointed, they declined, and they are doing well in politics as well as in practice.
Yeah.
So it may be multiplicity of reasons.
Yes.
The remuneration and the restrictions of becoming a judge.
Yes.
Ethically, you remove yourself from public life.
That's right.
And if you had the political interest, then of course that would restrict you. So, number of those reasons. Maybe partly, I think some may consider that the quality on the bench is not conducive to their desires.
Right. What would it's a good kind of segue for maybe a word of advice to younger lawyers or lawyers in general, maybe thinking about it, considering about joining the bench, showing their interest, and so on. What would your advice be to them, those lawyers who are considering potentially joining the bench?
I think the hard yards of work, the discipline and ethics involved in the legal work, and particularly practicing in court, that's where you cut your teeth as an advocate, as a barrister in the traditional sense. Your ability to think on your feet, yes, sharply, knowing the law and the legal precedents, and to be able to engage with the lawyers, with the judges in particular, and arguing your case.
Yeah.
This is what a good barrister, a potential judge ought to be, not just always deferring to what the judge might say to you, but being willing to take your position and debate the legal propositions with the court. So, as well as the ethical disciplines,
yeah,
they're critical to the discipline of becoming a judge.
Yes. Reflecting on your time at the bench now, you were there from 1983 to
1993 when
when did you retire?
2003.
2003, so almost 20 years.
Yes.
Well, exactly 20 years.
Exactly 20 years.
Wow. What would you say, in your observation, maybe during your entire tenure or earlier, generally the Supreme Court, what would you say are some of the most significant decisions that the Supreme Court has made that has impacted Papua New Guinea? Just, off the top of your head, some of those significant decisions that came out.
Yes, one of them, I was still in the public solicitors, landmark decision that kind of set the tone in a way on reflection about the localization of the bench. Was the Nahoruni case.
Right.
I think Sir Murray had gone to the court. I'm not sure now the dates, but I was still in the public solicitor's office when Nahoruni was our minister. Sir Murray had gone to the bench, first of our national judges. Sir Burry was not yet CJ. So the Chief Justice at the time was Sir William Prentice. And I was public solicitor. Sir Murray had gone to the bench when Nahoruni was our Minister for Justice. And she was ultimately prosecuted for contempt of the Supreme Court and sentenced to imprisonment. And the Prime Minister, who is the Prime Minister, he is the custodian of all ministries, and he delegates and appoints who shall be minister for this, that, or the other. Right. So upon Nahoruni's imprisonment, he retained the Minister for Justice, and exercising his power to release on license, released her from prison after one day, I think it was, which quite obviously was a confrontation with the judiciary. They impose a sentence of less than 9 months, which under the Constitution would not result in your disqualification. Any
Right.
imprisonment from 9 months and above, you are automatically disqualified from holding any public office. And so they imposed a sentence less than that, but the Prime Minister, Grand Chief Sir Michael, immediately released on license from prison. That resulted in a major confrontation and en masse resignation from some of the judges.
Oh.
That led to Sir Buri being appointed the first Chief Justice on merit. Is proficient and competent. So that was kind of a watershed tension between the executive and the judiciary. That still remains a case that guides how far the executive and the legislature can interact with the judiciary, the boundaries of each of the three equal arms of our government. Thereafter, then I went onto the bench, and I guess a number of major decisions that I participated in. One was the Vagrancy Act. At the time was challenged as being unconstitutional in 1988, I think it was. I thought 86, but I was on the bench. I checked up.
I think a decision came out in 88.
88, it might have been 86 was challenged.
Started, yeah.
Presided over by Soburi Kiru, and we ruled that aspects of that law was unconstitutional. The Vagrancy Act that infringed against the freedom of movement people, and as we speak, it is now being mooted. So it'll be interesting to see how that is being redrafted.
So that's a good point. Now that vagrancy is coming up again, or the act is coming up, or at least the issue at the policy level is being talked about. Especially here in Port Moresby, there's that question now of whether the Vagrancy Act should be reintroduced or enforced or applied in some way. In your opinion, as not as a judge then sitting on the case, and this might be a bit tricky for you to answer because you might be reviewing your own decision, but as a politician in Medang and then as a national leader now looking back, would things have been different if the constitutional challenge had not been raised regarding the Vagrancy Act and it was enforced by the powers that be, by the executive, obviously? Do you think it would have had we would have had a different kind of Moresby now if we were able to apply Vagrancy Act? Or
I'm not sure. Trying to proscribe, limit, restrict fundamental constitutional democratic rights is a tricky balance. But you can, the Constitution permits regulation. So going forward, whether it be freedom of assembly, freedom of association, freedom of speech, freedom of movement, the Constitution permits reasonable regulation justifiable in a democratic society for good governance, for upholding and enforcing the rule of law and law and order, and so on. So I think that's what is needed to ensure that when we are crafting legislation that has the potential to encroach upon, that we do not restrict and prohibit, we can regulate within reasonable bounds. I think this is where wisdom needs good legal counsel. And I think when we hasty, we can encroach on rights that is difficult to then correct. It's better to be cautious and slowly regulating and governing than being excessive and getting struck down. That results in confrontations unnecessarily.
Yes. One of the things that I noticed just briefly reading that decision on the Vagrancy Act is that the liberty of the person and then maybe the protection of law freedoms or rights were being infringed. I'm not sure if I'm interpreting it correctly because I should have read a bit more into it. But it seems like for the person who was accused of or arrested for offending the Vagrancy Act, meaning a person who was without the lawful means to support himself or herself and was pretty much a vagrant, that he or she were presumed guilty and then they have to prove their innocence. So it's a reversal of the presumed innocent until you're proven guilty. So it was a reversal of this. So this is my understanding that because they had the burden of proof of proving that they were not vagrants, rather than the state having the burden of proving that they were vagrants.
Yes.
So that would have been a significant, in my view as well. If I saw that, I would have thought that.
Yeah, I think if that were, my recollection is vague, but I think that if that were the case, that would have been wrong. You couldn't presume that, but you can regulate. You can travel. Your freedom of movement is not restricted. Your means is not a presumption of you're being guilty or vagrant, but there's got to be some regulation as to where you, when and how, where you can move. That enables you to have sufficient means to live.
Yeah, basically, they were, if they could not support themselves, especially within like Port Moresby, I think would have been the key place that you would have to be able to support yourself. And if they were not able to do so, then they would have been presumed to be vagrants. And from what I understand, the law at that time, the police could arrest you on the suspicion of vagrancy, and you'd have to prove that you were not a vagrant, which I think offends the principle of presumption of innocence. So,
no, as I've said, you can regulate that primary movement and demonstrate your ability to support yourself in order that you can move wherever you choose to. Like the classic example, I think, is when you apply for a traveling visa to visit another country, you must demonstrate the means of supporting yourself in order to be allowed to travel.
Coming back to the judiciary, in your observation now, what would be the most significant challenges that the judiciary faces at this time? And if I can premise this by saying, the public in general, in my observation, have lost a lot of faith in the executive and the legislative arms of government. They have significant trust left in the judiciary, but that's not infallible, and the people have to be continuously encouraged or given confidence that the judiciary is remaining independent and so on. What are some significant challenges that the judiciary is facing at this time?
I think that the tenure of judges, by and large, is reasonably secure because judges are appointed 10 years at a time. All the judges from Chief Justice downwards. The Deputy Chief Justice and other judges are appointed by an independent commission, the Judicial and Legal Services Commission. The Chief Justice is appointed by the government of the day, the cabinet, and also for 10 years at a time. So I think to ensure greater stability and consistency in tenure and retention of seniority and experience, the appointment of Chief Justice and all the judges needs to be followed. That's the Commonwealth and traditional process in most countries. In America, in different jurisdictions, it's little different. And that's life by retiring age. The retiring age is presently now 75, I understand, but that the appointments, so that of the Chief Justice in particular, needs to be removed from regular politicization of that appointment. I was succeeded again by the prerogative of the executive government at 52. I am still of serving age.
Yeah.
Sir Solomon, the immediate past Chief Justice, wealth of experience that's still needed on the bench, in my opinion.
Yeah.
There's no reason why any of us, once we're appointed at that level, we are apolitical.
Yes.
We have no political affiliation at all when we become judges. And so there's no reason for that continual changing that truly loses the continuity of the experience that we can bring to the bench. So that's been the unfortunate consequences of the regular turnover of the appointments of the Chief Justice in particular. I think the separation of the Supreme Court into becoming full-time by the introduction of the Court of Appeal recently is a good step. I myself did not and would not have brought in the Court of Appeal, but simply separated the full-time Supreme Court and retained the National Court and devolved more jurisdiction to the district courts, made them become district court judges or county court judges like in the Australian model.
Yes.
So that what is critical is expeditious disposition of case.
Yes.
There's far too prolonged outstanding decisions, and that is explicable. I experienced that in my own journey. It has to do with legal and judicial competence and experience in being able to churn out decisions quickly.
Quickly, yeah.
Many do not need to be reserved for lengthy periods of time. Yeah, if you're experienced enough, I've got the wealth of experience, you can issue decision instantly.
Yeah, extempore.
Extempore.
Yeah. I've observed that. I'm still waiting for some decisions like years now. And in one instance, the judge sadly passed away. And so there's it is probably a side note, but there's no provision for what happens if a judgment is delayed for X number of years. There should be a provision for revisiting that or retrial, or there has to be some way to bring matters to a close. So anyway, thanks for that. That's I think I agree with you in terms of at least the DCJ and the CJ level. Those I think should be life tenures.
Yes.
Or have until retirement age. Because the high turnover, you're right, we're losing judges who become chief judge, and just because the NEC or the executive loses favor or otherwise decides, let's have a change, it's not really a good reason to retire some judges who should still be on the bench. Anyway, let's come to the Constitution. What, in your opinion, is the strongest feature of our Constitution?
It empowers the people through the judicial arm to protect their rights and good governance. I think that's a feature that in many jurisdictions is often very proscribed. That means limited, and it takes a long time. In our jurisdiction right now, you can go directly to the Supreme Court through the right representative leadership and challenge any instance of alleged violation of the constitutional right. And the Supreme Court is vested with enormous power. And this is what needs to be understood. It's on behalf of the people. The people have vested their power in the Supreme Court. It's not assumed by the Supreme Court, and I have written and expounded on that quite elaborately that that right is not restrained by any letter of the law. It is generically universal. So it's called a 155 subsection for inherent power
Yep.
in the Supreme Court to administer justice, quote unquote.
Yes. What about on the flip side of that question, what would be the weakest feature of our Constitution?
I think that power goes with enormous responsibility. And that is why the three arms of government that have those co-equal powers to legislate, to run the country, and to uphold the rule of law and um, administer justice. So important for the custodians of those powers in each of those arms of government and the judiciary in particular to be absolutely above reproach,
Yeah.
incorruptible,
And be seen to be that.
be absolutely seen to
Yeah.
be that. And so anytime, particularly judges, it's an enormous power that carries overwhelming burden on your shoulders. That every word you utter is microscopically examined. And if our constituent population isn't sufficiently literate, you get away with unethical conduct.
Right.
And that ultimately falls back on the integrity of the individual custodian at every level. But in particular, the judges. That's why if you had a camera of what the previous judges and chief justices conducted themselves, you would see marked difference.
So you're saying it's a double-edged sword, that power by the courts it's like an unfettered power to dispense justice.
Almost.
It's a double-edged sword because it can be used maybe in a wrong way, I suppose.
Yes,
Yeah.
yes, it is enormous. In the political, executive, and legislative arms of government, you're subject to votes and election and so on.
Right.
In the judiciary, you're appointed for life.
Right.
And you're almost imprisoned, quote unquote, away from life.
Right.
You can interact, but with considerable restraint. And so what you say matters. How you say it, when you say it, matters.
Even outside of court?
Oh yeah, outside of court is when it's most significant. In court, every word you say carries authority. You find people guilty and you send them to prison. To say that I could do that sitting under a tree in t-shirt and you're guilty. And I sentence you to prison for life and my signature carries it.
Yeah.
I don't need to be robed in the regalia.
That's right. Yeah.
That's how much power that position carries. And therefore, in particular, outside of court, you are most ethically restrained.
Yeah.
What
it's very high level.
Can say.
The BSO, the basic social obligations under the preamble, I have this ick or something with the, in the basic social obligations, basic social obligation number 1 says we are to act and respect the spirit of the Constitution. And one of the things, you obviously having been in the country from day one, observing its nationhood and growth, one of the things that I kind of looking back, as far as I can, but also now, that seeing that Papua New Guineans don't really have a awareness, even a basic awareness of the Constitution. And yet it is a basic social obligation for us to act in the spirit of the Constitution. My question is, what was the thinking behind basic social obligation number 1, at least generally, in terms of the Constitution, making it become part of the ethos or the philosophy of Papua New Guineans. It seems like that, even though it was declared in the Constitution, it went missing. It wasn't part of our upbringing, our education system. Even me coming to law school, when we went through constitutional law in law school, we did not really look into the preamble of the Constitution, study the spirit of it as opposed to its letter. But what are your thoughts on making the population of Papua New Guinea be more constitutionally aware, at least of the basic principles of our nation?
I think that the national goals and directive principles, the preamble, needs to be unpacked and elaborated upon and amplified significantly. It contains a gem of wisdom.
Absolutely.
It is fundamentally Judeo-Christian, written by some very well-educated pioneer leaders. Contains the blueprint for a egalitarian society that is respected and prosperous. And we're all charged, every citizen and particularly institutional leaders in all the sectors, from church, private sector to governmental institutions, are directed to pay heed to those goals and directive principles.
That's
right. And I've looked at them in interpreting Constitution repeatedly.
Yeah.
And with the kind of moral and ethical values, we bring our the good traditional customs and values to the table with Christian adopted ethics and morality. You've got the package. We can run this country prosperously, successfully. Our communities, we're bringing the very best of our societies, traditions and customs with the modern economy and governance. The blueprint's there. We've just got to revisit it.
Absolutely. I would make it mandatory reading from grade 1 or even primary school. Make the preamble mandatory reading, print it out in booklets, give it to every citizen in the country. You have to carry around the Constitution, or at least the preamble, in your pocket. That my ideal world is that every Papua New Guinean should be reading the Constitution, or at least the preamble, and be aware of it.
I think the law school, the law society, has a moral duty to unpack this.
Yeah.
It's loaded
Absolutely.
with gems of value that, like I said, from a traditional custom, good values to our modern Christian ethics.
So that brings us to this current world we live in now, where we had a constitutional amendment 2 weeks ago, explicitly declaring PNG a Christian state. So I interviewed John Momis on this, and he's completely opposed to it, or at least doesn't think it's necessary. I'm kind of indifferent to it. I think it doesn't really add any legal merit to the Constitution. But I'm interested in your point of view, being a lawmaker, a judge, but also a Christian. What are your thoughts on the recent amendments?
If it were not promoted by the body of Christ, it wouldn't matter, because we already have adopted in the preamble Christian principles.
Yes.
I think that to me is the more important phrase, Christian principles.
Yes.
And we've declared this nation under the guiding hand of God. So those two are sufficient. We've not really truly lived up to those.
Mm-hmm.
as a Christian nation. Who is the God we're talking about? It's the Christian God.
Christian God, yes.
God the Father, God the Son, God the Holy Spirit. That's what that says. We've now amplified the triune God. And so that doesn't take that any further than the God that we've already honored as having declared this nation under the guiding hand of. And then to say we're Christian straight is simply reinforcing that. So I sat in a parliamentary committee on constitutional and legislative provisions between the two Johns, Sir John Captain on my left and Chief John Mommis on my right, and both of whom opposed that amendment. I supported it.
Okay.
And I was reported wrongly in the media for a week till it was corrected, because we already have asserted as having adopted Christian principles under the guiding hand of God, and we know that God of the Christian faith is God, the triune God. So it does not detract from the freedom of religion, Section 46. I think that's a misconception by many people, and to me, it merely reinforces and strengthens the fact of our practicing Christian faith by and large. We respect the practice of other religious faiths. We don't outlaw them. It's not intended to outlaw them. I think people had better fully understand that. But our nation is coming to nationhood on the basis of a lot of years of Christian faith contributing to our nation's development, education, health, social development, etc. And the values of our traditional faiths, good ones, are consistent with that. And so it merely strengthens that in my view. But what is important going forward, truly, even without this amendment, has always been the case before independence and particularly since independence, is what do we mean by Christian principles? What are those Christian principles that we teach in Sunday school, that we teach in church on Sundays? And the biggest challenge to the whole Christian church of this country, in my humble opinion, is to elaborate, to amplify, to disciple, to teach those Christian principles of the gospel of the Lord Jesus to us, the church. We, the 97, 90, and 98% in the marketplace, what those principles of love and forgiveness and fruit of the Spirit qualities and grace and mercy, and to practice them in life, in parliament, in the judiciary, in the public sector, in the private sector. Transform this nation with those values. Christian country, Papua New Guinea. Not rhetorical utterance nonsense. So that remains our challenge. That amendment doesn't transform us automatically. Law doesn't transform lives. It's our faith and practicing those principles that we sit under the teaching of in our churches.
Yes. Thank you. All right. We'll probably come to an end, but I have a few questions regarding like a unique perspective that you would have, and that's the perspective of a Supreme Court judge who decided a case or several cases on the provincial government system. And then eventually you became a practitioner of the provincial government system, particularly as governor of Medang. The case I want to mention is the Supreme Court reference number 2 of 1995, where the Western Highlands provincial government challenged the Section 10 of the Organic Law on Provincial Governments and Local Level, the new one that was enacted then. saying that it was unconstitutional. The Supreme Court, you included, held a view that it's not unconstitutional. Section 10, because the main challenge was that it created provincial assemblies that had both elective and non-elective members of provincial assemblies. That's the gist of it, if I'm correct. But you and the Supreme Court, your fellow judges, ruled that Section 10, meaning the makeup of the provincial assemblies, was not unconstitutional and therefore valid, of course, for all intents and purposes. Fast forward 2007, you became Medang
Member of Parliament, yes.
Yeah. And then you would have become the head of the provincial government of Medang. So my question is, having come from the bench, seeing the legal arguments that assembly is valid for all intents and purposes, but then becoming the head of the provincial government in an executive capacity. Now, what was your observation regarding the functionality or the effectiveness of provincial assembly? And that might be an assessment on all provincial assemblies. How, are they functioning as well as they should or could with the current makeup that they have?
Let's go back to that decision. When was that again?
1995, SCR number 2 of 1995.
Was that prior to the amendments that changed the composition?
It was after. So it changed the composition of the. So that's the current assembly, which has the members of the local level governments, the members of the national parliament who were elected, and then other members that are appointed, representative members. Church, women's rep, and then they can appoint. The assembly itself can appoint 3, say, leaders or and then it also says if there's a chieftain system in the province, then the chiefs can be appointed.
Like in New Ireland, as I understand.
Yes,
that's interesting. It'd be worth reading that decision again. Now, I've taken the view now that composition is unconstitutional.
Oh, okay.
Because it's not even mostly elected.
It's mostly not elected. Mostly ex officio.
Yes. The provincial member is the member of national parliament. All the open members are members of the national parliament. The presidents of the LLGs are presidents of local level government.
That's right.
And so the composite of that provincial government is ex officio, apart from the nominated members. So I've been saying that recently. The previous composition of electing your premier and other members, it was an elected assembly.
Yes.
So that needs to be seriously looked at, because you are imposing upon national members of parliament multiple legislative functions.
That's right.
Including the governor, who's representing the province, but runs an executive and legislative government. The presidents who are supposed to run the LFGs are also having the dual legislative functions, being LFG presidents and members of the provincial government. So that needs a significant review and overhaul.
Yes.
And then now, of course, with the DDAs, you're charging an open member with additional executive administrative functions. And consequently, they're not performing the primary responsibility of being national legislatures and policymakers. They are preoccupied with provincial affairs and local district affairs, administering service delivery.
Yes.
We've had, as we were saying earlier, a review of the systems of government charged upon the CLRC, Constitutional Law Reform Commission, and this report now awaiting government deliberation as to how to structure that, whether to retain the 3-tier system of government or to revert to just 2. That's the debate going forward. But I think that's really needs to be reviewed seriously.
Yeah. So generally, as a head of one-time head of a provincial government. Do you think it's a effective mechanism for service delivery right now, as it is?
The province can be. The provincial government, the subnational devolution of powers and functions to a lower level government, the decentralization model that was recommended by our constitutional founders and ultimate amendments is workable. It can be more efficient than presently being centrally controlled in many respects.
Yeah, my observation is that the central government has become, it's wrested too much power back from the provincial governments, and it's now controlling everything from Waigani.
If you listen to someone like Alan Bird, who has examined the micro economic distribution of the resources, the budget that goes to the provincial government is very minimal. Most of that is centrally controlled, and that leads to poor service delivery.
Yeah. All right. Well, thank you. Coming now, we'll end with your current role or current designated role. Congratulations on being appointed to be our ambassador to the United States. What's the feeling like? What's your understanding of your role as our ambassador? You get to rub shoulders with, I suppose, Secretary Rubio and potentially Donald Trump, the president. What are you?
Well, I think it's an exciting opportunity at this present time in geopolitics. We have a new president of the United States, who is impacting global geopolitics, the European Union, the American, and the world as we speak, and our own place in that is important. We're not just a tiny drop in the ocean nation. We are a significant nation in the Pacific region and the hub of Asia Pacific, where we are located. And we have an important multilateral role in the region. We are the big brother sitting on the table with the Pacific Island nations, and a observer in the ASEAN region. Our position geographically commands us to have a place on the table. And so I think representing a nation anywhere, for that matter, not just because it's the United States, is an honor that I have accepted with considerable sense of responsibility. I need to understand the dynamics, bringing to the table all of my experiences. And it's a new role from being a lawyer, judge, politician, to be a diplomat. I've got to understand the dynamics of development in our nation and how that we can engage with other nations of the world in how to improve and enhance our nation's development. I think that's a challenge, and we have much to improve upon.
Yes. Well, final question. I like to always end on a positive note with people I interview. So my final question is, looking forward, what makes you optimistic about the future of Papua New Guinea?
I'm an optimist by nature. You have faith in God, personally, firstly, in your own life's journey. If you've done well and can still see potential in how God can use you from where you came, then you must have similar faith in God's created human beings. This is God's created nation. We are custodians and stewards to steward and to serve in the finite time we have, we can do much better. I believe in all the gifts that God has gifted Papua New Guineans. If I have it in my own little journey to where I am, then so could everybody else in varying measures. And so why then I have such passion for education. I've had the benefit of education that we described. Why is it that our children, grandchildren, great-grandchildren at my age not having the same opportunity? Why would 70% be pushed out after grade 8, after grade 10? That's a national disgrace. We can do much better than that. And so our vision for not leaving one child behind, we really have to ramp up and honor ASAP like yesterday, so that many doctors and lawyers and engineers like you and I can have the opportunity. And so the future has tremendous potential. It's God's creation. We are mere custodians. We're transient.
Yes.
And so all of us have a responsibility. Because at the end of the day, my conviction as a Christian, having had the benefits of God's blessings in my life, stand before the Chief Justice of all judges and answer what I did with what he gave me. I would pray that he would say to me, "Well done, my good and faithful servant, enter into the joy of the Lord." That is the vision and the passion that inspires me to keep on believing that we can, we must, we can't afford to drop the ball on PNG. God bless.
God bless. Thank you. Say Arnold, thank you so much for sharing all your thoughts and wisdom with us. And we wish you all the best with your mission to the United States. And yeah, Godspeed.
Thank you.
Thank you.